Senate will come back to order. Chair recognizes the senator from the 29th for a motion.
Mr. President, I respectfully request that we move House Bill 411 from the table.
Mr. Secretary, will you please read the caption, House Bill 411?
House Bill 411, a bill by Representative Gullett of the 19th, a bill to be entitled an act to amend Article 1 of Chapter 18 of Title 15 of the Official Code of Georgia Annotated, related to general provisions regarding prosecuting attorneys so as to create the Prosecuting Attorneys Oversight Commission, to provide for definitions, to provide for powers, composition, appointment, and confirmation of such commission. The Senate Committee on Judiciary recommends that this bill do pass by substitute. Respectfully submitted. Senator Strickland of the 17th. That concludes the order, Mr. President.
Senator from the 29th has asked for House Bill 411 to be taken from the table. Is there objection? There is objection. All right, it's a non-debatable objection. All those in favor of House Bill 411 be taken from the table will vote yea. Opposed, nay. The Secretary will unlock the machine. Have all senators voted? There's some more in the hallway. Mr. Secretary, will you please close the machine? On the motion, the yeas are 13, the nays are 23, and this bill has failed to come off the table and still lays on the table for later action. Mr. Secretary, Chair recognizes the senator from the 50th.
Mr. President, I ask that we remove House Bill 218 from the table.
Mr. Secretary, will you please read the caption?
House Bill 218 by Representatives Ballinger of the 23rd and others. A bill to be entitled an act to amend Code Section 16-11-126 of the OCGA relating to having or carrying handguns, long guns, or other weapons license requirement and exceptions for homes, motor vehicles, private property, in other locations and conditions, so as to expand weapons carry license reciprocity in the state to provide that persons who are not residents of the state shall be authorized to carry a weapon in the state if licensed to carry in any other state and for other purposes. The Senate Committee on Rules recommends that this bill do pass by substitute. Respectfully submitted, Senator Mullis of the 53rd. Chairman. The Senate Committee on Rules offers the following substitute to House Bill 218, a bill to be entitled an act to amend Part 3 of Article 4 of Chapter 11 of Title 16 of the OCGA relating to carrying and possession of firearms so as to expand weapons carry license reciprocity in this state to provide that persons who are not residents of this state shall be authorized to carry a weapon in this state if the license to carry in any other state.
We have an amendment.
Just one.
We're good. It's not in there. Hang on.
We're holding for 1 second to read an amendment that's being printed.
Senator Anna Vitarte of the 31st offers the following Amendment 1 to amend the substitute to House Bill 218 by inserting after remedy on line 15 the following: to provide a limitation on the governor's powers to control the practice of any religion during an emergency, to provide for the continued operation of organizations during a public health state of emergency if they comply with certain health and safety measures, to provide for a definition, and for other purposes. This completes the order, Mr. President.
Senator from the 50th. Senator from the 50th has moved that House Bill 218 be taken off the table. Is there objection? There is objection. All those in favor of the Senator from the 50th's motion to take House Bill 218 off the table, vote yea. Opposed, nay. The Secretary will unlock the machine. Have all senators voted? Have all senators voted? Thumbs up. Ms. Secretary, please close the machine. On the motion, the yeas are 32, the nays are 18, and House Bill 218 has been taken off the table. The chair recognizes the senator from the 50th to speak to the measure.
That's right. Thank you, Mr. President. I rise today to bring House Bill 218. This has been a concerted effort with House members and the governor's staff, and I'm proud to say that this bill will protect the Second Amendment rights of Georgians. There are several provisions that will protect the Second Amendment rights of Georgians. Section 1 deals with weapons carry permits from other states. Current law authorizes any person licensed to carry a weapon in the state of Georgia whose laws any person who's licensed in another state whose laws recognize Georgia's has reciprocity. Now we're going to open that up, and anyone with a concealed weapons permit in another state that comes into Georgia will have reciprocity. Georgia will recognize those. Section 2, this section allows a probate judge to implement online application processes for weapons carry license and renewal licenses. It also allows the judge of the probate court to accept a weapons carry license renewal or license carry application by first-class mail. Further, this section protects the Second Amendment rights of Georgians by preventing anyone or any entity from creating or supplying any database with information regarding individuals who possess or who have applied for a weapons carry license. Section 3 of this bill addresses the disposal of unclaimed firearms. It will require state and local law enforcement agencies to hold auctions at least one time every 12 months to auction off confiscated and unclaimed firearms. It further allows that members of the general public can bid on such firearms and that the winning bidder may take possession of the firearm once it's transferred to a licensed gun dealer, collector, importer, or manufacturer, who then must comply with all state and federal laws before transferring the gun to the highest bidder. Section 4 does many things to protect the Second Amendment rights of Georgia's citizens and businesses or business owners during states of emergency. First and foremost, it prevents government officials from singling out or closing or limiting operational hours of businesses engaged in manufacturing, sale, or repair of firearms, ammunition, reloading equipment and supplies, or other weapons. It further limits any governmental body from seizing firearms and ammunition during a state of emergency. It further prevents government officials and employees from prohibiting the manufacture, sale, or transfer of firearms, ammunition, reloading equipment and supplies, and other weapons during a state of emergency. It also prevents the government from singling out and closing the operational hours of shooting ranges. Finally, Section 4 allows individuals whose rights are violated by any government official or employee to bring an action in mandamus or other lawsuit to seek declaratory or injunctive relief. Section 5 prevents this governor or any future governor from suspending the code section prohibiting government officials and employees from seizing weapons during a state of emergency. As previously stated, this is a Second Amendment protection bill that further recognizes Georgia's commitment to protect its citizens and their Second Amendment rights. With that, Mr. President, I'll yield the will.
Senator has yielded the well. Chair recognizes the senator from the 42nd to speak to the measure.
Thank you, Mr. President. I gave the Secretary of the Senate's office this graphic, which I'm hoping will be displayed shortly, but if it's not, you will hopefully have it at your desk, but hopefully it will work. I am going to tell you the story of Tom Sullivan. Tom is a father. He's a veteran of the United States Air Force. He was a postman and a journalist. But the important thing about Tom's story is that he is a father. Tom and his wife raised their 2 children, Alex and Megan, in Centennial, Colorado. Tragedy struck Tom's family on the night of July 20th, 2012. That night, Tom's son Alex was celebrating his 27th birthday at the Century Theater in Aurora, Colorado, when a man opened fire in the darkened theater during the eagerly anticipated premiere of The Dark Knight Rises. Alex and 11 others were murdered in that mass shooting. At the time, but certainly not anymore, the largest mass shooting in U.S. history. In a statement about his son's murder, Tom said, "As a father, when it really comes down to it, you've got one job. You're supposed to keep your kids safe." I failed Alex. I didn't keep him safe because I didn't know. I didn't know that he couldn't go to the movies on his birthday. I didn't know what was out there. I didn't know what to keep him from. I didn't know. So what do we know? There is overwhelming evidence that our country has an atypical problem with gun violence because we have a unique saturation of guns. And it doesn't look like it's up there, but if you look at the document that I put on your desk, okay, can I see the other one first, Mr. Secretary? You will see that America is quite the outlier when it comes to number of firearms out and about in the general public. You will see that America is quite the outlier when it comes to the numbers of people dead by firearms every year. You will see that those two things are directly correlated. The country closest to us, guns per 100 people, United States 120, Canada 34, and on down the list. Down to Japan, which has 0.3 guns per 100 people. In total, there are almost 400 million guns in the United States today. There are a lot more guns than there are people. United States, states in our country that have higher gun ownership rates and fewer restrictions on guns have, as is demonstrated in this chart when you look at us in comparison to other countries around the world, the highest rates of deaths by firearm. Alaska, Louisiana, Alabama, and Mississippi rank in the top 4 for highest rates of gun-related deaths, with rates that are higher than 22 gun deaths per 100,000 people. Alaska's gun ownership rate is 60%. Louisiana, Alabama, and Mississippi are not far behind, with about 50% of the adults owning guns. And the death rates in those states are the highest in our country. And it goes from there. In contrast, New York, Rhode Island, Massachusetts, and Hawaii are at the other end of the spectrum, with rates lower than 5 gun deaths, that's versus 22, per every 100,000 people. These states have gun ownership rates below 20%. Only 10% of adults in Massachusetts have a gun in their home, and it has the lowest gun fatality rates in the United States. So it's the same thing per US state as it is when you look internationally. The more guns are everywhere, the more people die of guns. So I want to make sure that none of you can say, I didn't know. You can see it right here. More guns, more gun deaths. So now you know. And this legislation adds more guns to our overarmed and overweaponized society. Americans aren't more violent than people born in other countries, but we do have a lot more guns. So what do we need to do? We need to study gun violence as the public health problem that it is. for cancer, car crashes, plane crashes, heart disease. For COVID-19, we react with alarm when people die, and we commit public funding to try to do something to lower these fatality rates. Can you imagine if, when confronted with the COVID-19 crisis a year ago, the US government said, oh well, and didn't commit any public dollars to the development of a vaccine? But when it comes to deaths by firearm, that's exactly what we have done and exactly what we did for 20 years. More than 20 years ago, Congress stopped federal funding for gun violence research by including a provision known as the Dickey Amendment in legislation. This was led by Representative J. Dickey of Arkansas at the behest of the NRA. And the amendment's goal was to prevent gun violence from being treated as a public health issue. So for the next 22 years, the CDC in my district was prevented from studying and researching the causes and the prevention of gun violence. But as mass shootings and gun violence became increasingly prevalent in the United States, so did criticism of the Dickey Amendment, with even Representative Dickey publicly changing his stance before he died and declaring that he had been wrong in sponsoring the Dickey Amendment. Research works. We can look at another industry that used to be far more fatal than it is today, the automobile industry. Prior to the enaction of seatbelt laws, death or injury caused by motor vehicle accident was extremely common in numbers that would shock you today. And yes, people railed against the seatbelt laws as government interference, but they saved lives. As automobile technology advanced, more safety measures were added and more lives were saved. And listen to this. As a result, the rate of traffic fatalities has decreased from more than 15 per 100 million miles to just above 1 per 100 million miles today. That's because there was public health research and industry research into the way cars were manufactured, the way we set up driving, the way we constructed our roads to make them safer, to ensure that less people would die when using cars. And that's the same thing we need to do with guns. The answer to mass shooting and gun violence in the US is not to take everyone's guns away, but to do more research and treat this epidemic as the public health issue that it is. So you might be wondering, what happened to Tom Sullivan, the Colorado father? Well, he went to the state capitol in Denver. And when his representative disregarded his story and disregarded Alex's story and voted with the gun industry, he ran for office. And in 2018, Tom Sullivan became the first Democrat elected to represent House District 37, defeating the incumbent who voted with the gun industry instead of his constituents. So let that be a warning to all of us. We don't have to live like this. We don't have to see 3 establishments shot up and 8 people dead in our state to be followed 6 days later by 10 more people dead. We don't have to live in fear of the next mass shooting. We don't have to bear this huge number of grieving families. Americans aren't more violent than other human beings. Second Amendment rights, that's great. But we need to also talk about saving lives. And Mr. President, if there are no questions, I will yield the well.
You have questions.
Okay.
Chair recognizes the majority leader to your left.
Thank you, Mr. President. Will the senator yield?
Yes, sir.
And I, too, am deeply disturbed by the number of people that have died here in the last couple of weeks to a mass shooting. I do have a question for you, though. On your chart, you left off Switzerland. Is there a reason that you left Switzerland off your
No,
chart?
Switzerland's on the chart.
Switzerland, 25% of the citizens of Switzerland have guns.
Switzerland is on the chart. It says Switzerland has 27 guns per 100 people to our 120.
Okay, I was wrong.
And it says
27%.
that their fatality rate is 0.2 per 100,000 people.
That was my question.
Yeah.
If a quarter of Swiss, and it is a quarter, and I can go into great detail of why it's a quarter of the Swiss citizens have guns, why is their murder rates by gun so much lower?
So if you look at this, you'll see that we have 5 or 6 times as many guns as they do, but our murder rate is still higher than that would suggest. And I have not studied the Swiss recently. I'm more worried about America.
Thank you for that catty response, but you put the chart out there.
Okay.
And I'm asking you,
I don't know.
I'm asking you for an explanation of, you're saying that we're not, we don't have a different set of issues than you have put it on the gun itself. And I don't want anybody killed by anybody, regardless of the method of which they were killed. But the Swiss have a much higher gun ownership per person than the U.S. does.
No.
And they do.
No, we have 120 per 100 people, and they have 27 per 100 people.
27% of Swiss.
Well, that's not what the chart says,
Okay, I know
so.
it's not what the chart says.
Yeah.
I'm telling you, when you get back to your desk.
The
I'll
chair
look it
would
up.
encourage this conversation to be questions
That's
and
fine,
answers.
yeah.
Thank you. Are you familiar with the Brady Bill?
From 1990, after Reagan's shooting.
That's correct.
And Brady, yes, they formed the
Yeah.
organization and passed it. I am somewhat familiar with it. It was passed many years ago now.
Yes, it was, and it did a lot of controls against assault weapons, magazines, and it was, everybody at the time thought this was a very well-intentioned bill. Unfortunately, the first mass shooting in a school happened during the time of the Brady Bill. So I guess where I'm going on this is those limitations don't stop this. There are other issues out there, would you not agree, that we need to address?
I actually don't agree with the way
Okay.
you phrase that,
Thank
and
you.
let me explain why. The reason is that you can never stop all gun deaths or mass shootings, but you can stop some. And some of the statistics I mentioned in my remarks show that. The other response I have to that is that, an anecdote does not create a trend line. What you need to do when you're looking at public health is look at trend lines.
That is the start of a trend line that has continued since that point. Thank you, Senator. I have no further questions.
Chair recognizes the senator from the 48th for a question.
Thank you, Mr. President. Senator, do you yield?
I yield.
Great. Isn't it true that during a state of emergency, the focus should really be on public safety, not curtailing the governor's powers or stymieing the effectiveness of local law enforcement?
Oh, I completely agree. I didn't even get into that part, but you need someone with the flexibility and authority to act decisively on behalf of your state when there is a public health emergency, and that person is the governor.
Good answer. Do you further yield?
Yes.
Isn't it also true that firearms don't make people safer during a pandemic, and that restricting the governor's ability to close or limit gun store operations puts their owners and customers at risk?
I agree.
Do you further yield?
Yes.
Is it not also true that during the pandemic we saw an increased risk of domestic violence and suicide as tracked by hotlines around the country that had increased volume by 300%?
Absolutely true.
How does this bill make people safer?
It does not make people safer.
And the final thing is, isn't it also true that the vast majority of incidences of gun violence are in fact not mass shootings? But
That is
these-
absolutely true. They're the ones that get a lot of attention because they're so shocking in the moment. But that's what I was trying to get to with some of what I was saying about needing to study it as a public health issue, because it's the daily deaths, murders, and let's talk about suicides for a second. People sometimes think, and it's totally wrong, that if someone died by suicide, they should be disregarded or not included in public health statistics as it relates to firearms. That is totally erroneous, because it's when you're having that moment, if you have the easy availability of a lethal weapon, that's when you die. And if you don't have a gun handy, the chances of living and surviving that and going on to not be a statistic of suicide are actually quite high.
Final question related to your last. Isn't it true that only about 4 or 5% of suicide attempts are inflicted by a firearm, but of those, 50% are fatal?
That's
And
exactly right.
people who attempt suicide by firearm are 90% successful?
That's exactly right. Exactly
you.
the problem.
Chair recognizes the senator from the 13th for a question.
Senator Yield.
Yes, I yield.
Senator, and I understand what you're saying. I want you to know, there's not a person in here that's, the shootings are terrible, and but it's a hate crime is the way I see it. It's a hate crime. Having said that, in that theater where the people were killed, isn't it true that if one person in that theater that was carrying or had a gun on them at that time, legal gun on them at that time, had fired back at the assailant, that might have saved lives and
No,
stopped the shooting?
Absolutely not, Senator, and let me explain why. So this was a darkened theater. Trained law enforcement who train nonstop still only hit their target, and I might get this wrong, maybe the senator from the 29th can let me know, but it is a low percentage of times. It's like 20% or 30%. No, untrained people in a darkened theater when the guy starts shooting with rifles, are not gonna be able to take out the assailant.
Senator Yield?
Yes.
I didn't mean as in take out the assailant. I mean just the sound of gunfire like a rattlesnake. I mean, if somebody hears gunfire, they're gonna duck. And if somebody's shooting at somebody and they hear gunfire, chances are they're gonna duck. I'm simply saying that if you look at the statistics behind it, that person who was doing the shooting might not have been able to take out 12 people. He might have gotten 2 or 3, but somebody could have fired in the air or fired blindly and at least stopped the shooting. That's my point.
Well, no, because see, the problem is with what I was saying about the lack of accuracy, you would be that much more likely to kill somebody else. And the former senator from the 6th and I had a lot of conversations about this because he knew from his military training that you cannot overcome the element of surprise. So he would tell me, look, this stuff, because you can never overcome the element of surprise. Even trained law enforcement struggle with it, and as I say, their accuracy is low. So Joe Schmo, the number of people that successfully stave something off are unfortunately tiny compared to the numbers of deaths that we have because of the proliferation of weapons. There's just no comparison on those two statistics, unfortunately.
Point of clarification, I was simply saying if someone even shot at the roofs, at least they would have the ability to duck or at least made the sound like someone was trying to fight back to at least have a chance of saving their life if they had their gun.
Well, I guess, so the guy...
The chair would encourage this conversation of questions and
Sure.
answers, please.
Thank you, Mr. President.
I'm happy to yield the well, Mr. President.
Senator has yielded the well. Chair recognizes the senator from the 31st to speak to his amendment.
Thank you, Mr. President. I'll be brief. Amendment number 1 is very similar language that you all have seen before and everyone has voted on. 1 is basically creating, during a state of emergency, protecting our religious rights during that time. And then the second part also is related to creating a pathway for businesses and corporations to be open. So during any state of emergency, the governor enacts in the state, which is also being supported by the National Federation of Independent Businesses and Small Restaurant Association and others. So with that, Mr. President, I yield the well.
Senator has yielded the well. Does any other senator wish to speak for or against the measure or the amendment? Ask that in the form of a question. The chair encourages the senator. For what purpose does the senator from the 26th rise?
Is the amendment germane?
Please stand at ease for a moment while we address the question. Senate will come back to order. The chair has analyzed the question raised by the senator from the 26th on germaneness of the menu. Section 5 of the underlying bill of House Bill 218, Section 5, deals with the governor's powers, and the amendment number 1 offered in Section 6 also deals with that same posture. The ruling of the chair is that the amendment number 1 is germane. For what purpose does the senator from the 26th rise?
Parliamentary inquiry.
State your inquiry.
Mr. President, isn't it true that the bill deals with guns and the other one deals with the opening of businesses?
The chair has spoken to that both subject matters are being referenced back to the powers of the governor. For what purpose does the senator from the 36th rise? She waves. All right, any other senator wish to speak for or against the measure or the amendment? The chair sees none. Would the senator from the 50th like to close debate? He would. Chair recognizes the senator from the 50th to close the debate.
Thank you, Mr. President. This is a friendly amendment that's been offered. It protects Georgians' First Amendment, and I would ask for your support in the amendment and the underlying bill. Thank you, Mr. President. I yield the will.
Chair recognizes the majority whip.
Ask for unanimous consent to excuse the senator from the 47th.
Without objection, the senator from the 47th is excused. All right, we'll take up amendment number 1, the adoption of amendment number 1 by the senator from the 31st. Is there objection? There is objection. All those in favor of adopting amendment number 1, vote yea. Opposed, nay. The secretary will unlock the machine. Pretty much right where you predicted it. Have all senators voted? Have all senators voted? Mr. Secretary, please close the machine. On the adoption of amendment number 1, the yeas are 34, the nays are 18. And amendment number 1 is adopted. All right, now we'll take up the measure. The question is on the adoption of the committee substitute as amended. Is there objection to adoption of the committee substitute as amended? Chair hears none. The committee substitute as amended is adopted. Is there objection to agreeing to the report of the committee which is favorable to the passage of the bill? The chair hears none. The report of the committee is agreed to. Is there objection to the main question being ordered? The chair hears none. The main question is ordered. Questions on the passage of the bill by substitute. All those in favor vote yea. Opposed, nay. The secretary will unlock the machine. Have all senators voted? Ms. Secretary, please close the machine. On the passage of the bill, the yeas are 34, the nays are 18. This bill, having received the requisite constitutional majority, is therefore passed by substitute. Chair recognizes the senator from the 29th.
Mr. President, I respectfully ask for House Bill 495 to be taken off the table.
Mr. Secretary, please read the caption.
House Bill 495 by Representatives Crowe of the 110th and others. A bill to be entitled an act to amend Article 1 of Chapter 3 of Title 35 and Article 2 of Chapter 1 of Title 42 of the OCGA relating to general provisions regarding the Georgia Bureau of Investigation and the Sexual Offender Registration Review Board, respectively, so as to revise the duties of the Georgia Bureau of Investigation and for other purposes. The Senate Committee on Public Safety recommends that this bill do pass. Respectfully submitted, Senator Albers of the 56th, Chairman. This completes the order, Mr. President.
Senator from the 29th has asked for unanimous consent for House Bill 495 to be taken off the table. Is there objection? The chair hears none, and it is taken off the table. The chair recognizes the senator from the 29th to speak to the measure.
Thank you, Mr. President. Colleagues, 495 deals with the Sex Offender Registration Review Board. Currently, the review board has two individuals working to keep track of the responsibilities of maintaining the review board. This bill transfers this responsibility from the GBI directly over to the Sex Offender Review Board. The board will now be responsible for acquiring, collecting, and analyzing information, including but not limited to criminal history record information, and determining a sex offender's risk assessment. The board may employ investigators to complete these duties, and the GBI is still responsible for maintaining at least one position under its administration and supervision to facilitate the provision of the summarized criminal history record information to the board from the Georgia Crime Information Center and NCIC. Basically what this does, it makes sure we have a balanced approach when addressing the criminal histories of sex offenders, especially when it comes to the classification of individuals as predators or as non-predator sex offenders. And I encourage your support for House Bill 495. Thank you, Mr. President. I yield the will if there are no questions.
You have no questions.
Thank you.
Any other senator wish to speak for or against House Bill 495? The chair sees none. Is there objection agreeing to the report of the committee which is favorable to the passage of the bill? The chair hears none. The report of the committee is agreed to. Is there objection to the main question being ordered? The chair hears none, and the main question is ordered. Questions on the passage of the bill. All those in favor vote yea. Opposed, nay. The secretary will unlock the machine. Have all senators voted? Mr. Secretary, please close the machine. On the passage of the bill, the yeas are 50, the nays are 1. This bill, having received the requisite constitutional majority, is therefore passed. Chair recognizes the senator from the 50th for a motion. I know it's hard to believe, but you got another bill.
Which bill is it? Mr. President, I move that we remove House Bill 114 from the table.
134?
134 from the table, excuse me.
I knew what you meant. Mr. Secretary, can you please read the caption of House Bill 134?
House Bill 134 by Representative Anderson of the 10th and others. A bill to be entitled an act to amend Chapter 14 of Title 50 of the OCGA relating to open and public meetings so as to exclude meetings relating to cybersecurity contracting and planning from open meeting requirements, to amend Article 4 of Chapter 18 of Title 50 of the OCGA relating to inspection of public records, so as to provide an exemption for certain documents relating to cybersecurity plans and systems and for other purposes. The Senate Committee on Science and Technology recommends that this bill do pass. Respectfully submitted, Senator Dolezal, the 27th, Chairman. This completes the order, Mr. President.
Senator from the 50th has moved that House Bill 134 be taken off the table. Is there objection? The chair hears none, and it is removed from the table. The chair recognizes the senator from the 50th to present the measure.
Thank you, Mr. President. I come to the well today to present House Bill 134. This bill will allow that meetings with discussions regarding cybersecurity related plans, procedures, and contracts be held in executive sessions of governing bodies rather than be open to the public. And if there are questions, I will yield for questions.
You have no questions.
With that, I'll yield the well.
Any other senator wish to speak for or against House Bill 134? The chair sees none. Is there objection to agree on the report of the committee which is favorable to the passage of the bill? The chair hears none. The report of the committee is agreed to. Is there objection to the main question being ordered? The chair hears none. The main question is ordered. Questions on the passage of the bill? All those in favor vote yea. Opposed nay. The secretary will unlock the machine. Have all senators voted? Have all senators voted? Mr. Secretary, please close the machine. On the passage of the bill, the yeas are 51, the nays are 0. This bill, having received the requisite constitutional majority, is therefore passed. Chair recognizes the senator from the 46th for a motion.
Thank you, Mr. President. I move that we agree to remove House Bill 479 from the table.
Mr. Secretary, please read the caption of House Bill 479.
House Bill 479 by Representative Reeves of the 34th and others. A bill to be entitled an act to amend Title 17 of the OCGA relating to criminal procedure so as to revise certain arrest powers, to provide for arrest by law enforcement officer outside the jurisdiction of his or her employing law enforcement agency under certain circumstances and for other purposes. The Senate Committee on Judiciary recommends that this bill do pass. Respectfully submitted, Senator Strickland of the 17th, Chairman.
Amendment 1, Tippins.
Senator Tippins of the 37th and others offers the following Amendment 1 to amend House Committee substitute to House Bill 479 by replacing line 72 with the following. Retail establishment or food service establishment or any business owning personal property located on their property or on the property of others on which they are conducting their business activities and for other purposes. This completes the order, Mr. President.
Senator from the 46th has moved that House Bill 479 be taken off the table. Is there objection? Chair hears none, and it's taken off the table. The chair recognizes the senator from the 46th to present the measure.
Thank you, Mr. President, ladies and gentlemen of the Senate. Pleasure to be with you this afternoon to present this bill, which is really in many ways a progression on the hate crimes bill that we passed last year, back in June. This really came about in response to the Ahmaud Arbery situation down in Brunswick as people began to learn about the citizen's arrest law of the state of Georgia. Many of you probably never heard about it or thought about it or even knew the term other than from watching old Gomer Pyle shows, or I guess he was on Andy Griffith when he was initiating a citizen's arrest, but we just very seldom see this used in real life, but that became part of the news story there. And it made all of us kind of re-examine a little bit about what is appropriate conduct towards each other, especially when you observe or see or suspect criminal activity. I think that all the states have something similar to this.
Senator, could you suspend for a moment?
Be happy to, Mr. President.
We could come back to order and give our attention to the senator in the well. I can assure you we'll get better work productivity and we'll be done quicker if we can all pay attention. Thank you. Proceed.
Thank you, Mr. President. So it turns out we have had a law in Georgia that dates back to 1863 that did allow citizens to assist others or make an arrest to prevent escapes and to otherwise assist law enforcement along the way. We have had that on the books for many years, and some of this recent examination made folks try to decide, did we still need it or not? What this bill does, and I'm going to hop around a little bit in it so you can follow me, but on page 3, section 2, we essentially repeal our current citizen's arrest law. There were 3 different code sections that dealt with the right to arrest another citizen, what you did if you did make such an arrest, how to turn them over to law enforcement, and what your rights and duties were under those circumstances. We are repealing that completely, and we're replacing it with a new scheme. It's not drastically different, and there's certain things that remain in the law. And I'll start with the first section of the bill, section 1, which goes through how this applies to law enforcement. We definitely want law enforcement to enforce our criminal laws. They're the people that are best trained to do it. We were having a discussion here a minute ago about firearms and training in firearms, but they know what the laws are. They know what to look for as far as violations. They know how to handle people that they're attempting to apprehend in a way that does not endanger other citizens or members of the public. So we want to make it clear that any officer can still make an arrest, certainly if they have a warrant, but here at line 29 and 30, any other offense where they see the offense take place, if it's in their presence or in their immediate knowledge. And it goes on down, it goes through a series of things down to line 42 and 43 for any other cause if there's likely to be a failure of justice for want of a judicial officer to issue a warrant. So if they can't get to a judge to have a arrest warrant issued and somebody's about to get away, leave the jurisdiction, etc., they have the ability to do it. The top of page 3, it deals with what happens when a law enforcement officer is outside of their jurisdiction. Okay, I'm from Clark County, so Clark County officers have the right to enforce the laws within Clark County ordinarily, and that's where when they hit the county line, generally speaking, they're not able to go into other counties and make arrests. So when they're no longer acting under the cloak of authority, they are in the position of a citizen. And we just abolished citizen arrest here if this bill passes, and so they'd be unable to make those arrests unless we provided for it here. So we're reincorporating into the law what many, many years, decades of case law established what police officers could do outside of their jurisdiction. And once again, if they observe a crime, if they see it happen, I'm now at line 48, or have immediate knowledge, they can make an arrest even if they're outside of their home jurisdiction. The second there at line 50 is if they are pursuing a criminal and they go across county lines. We call that hot pursuit. When you are involved in a chase, when you're trying to apprehend a criminal, he can't get away by going across the county line and saying, nah, 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 you can't get me now, I'm out of your jurisdiction. You can follow them and do that, and we make it clear here. And number C there at line 53, if they are aiding or assisting other law enforcement in another county. I can think of many examples in Athens when we have home football games. We've got officers from all over the state assisting our local officers in crowd control, et cetera. So if they are lawfully assisting other law enforcement outside of their home jurisdiction, they are able to help. Some of you may have heard from law enforcement that they had concerns about this or were worried about it. That is the provision, as far as I know, that they had concerns about. It was addressed before the final version came out of the House. And so what we have basically abolished citizens arrest, but reincorporated it for law enforcement officers acting within these parameters. There are other areas where we have reincorporated it. If you're following along down at the bottoms of line 3, starting at page 65, we have created a new citizens arrest law, Title 17-4-80, but it is very limited, or more limited than the very general law that this repeals. You will see at line 76 where it allows the owner of a retail establishment to detain somebody. If there's a shoplifter there on their premises, or the theft, stealing things by the unlawful use of a sales receipt, like going back and turning product in and getting cash for it, et cetera, or theft of unlawful use of retail sales of any type. If the shop owner sees somebody stealing in their store, we are allowing them to detain somebody. So we're reinstituting the same principle as citizen arrest for if somebody that owns a retail establishment observes or reasonably believes that somebody there is committing shoplifting. At line 81, we're also extending that to the retail food services. Anybody who owns a food service establishment that thinks somebody is attempting to commit theft by taking or theft of services from them. So we used to call it walking the tab. Not that I ever did it, but I heard about it. Saw some people, if you order food, you enjoy the food and beverages, and then you try to leave without paying, that's no different than shoplifting, taking something from you. If the owner of the food service establishment sees that happening, has reasonable cause to believe it, then they may detain you. So this is the second exception we're carving out for citizens to handle the detention of somebody that's a criminal that's going to get away with a crime if they don't hold them. Now there's a provision there at lines 89 that if you do that, so if you're the shop owner or the retail food service establishment owner and you're detaining somebody, you have to release them within a reasonable time, or else contact law enforcement to come make the arrest. So what we're doing is leaving this up to law enforcement to actually make the arrest instead of citizens trying to arrest people and trying to enforce laws that they may not be adequately trained in or even know. But we're protecting these citizens in ways they have in the past by stopping theft in their own premises, whether they're a retail establishment or a food service establishment. But you can't just hold somebody there, put them in your holding cell overnight. You've got to call the law enforcement, ask them to come assist you with this person that you believe has committed a crime. Or else, if they won't come within a reasonable time, you have to go ahead and let them go. And what you should do, and this makes you do it when law enforcement arrives, is you have to surrender this suspect over to law enforcement along with their personal belongings, whatever you may have held of theirs. Now, none of this should require any deadly force, getting back to some of the tragedies we've seen in the news recently where people are using deadly force to try to stop crime or accuse people of crime. This is just stopping people from theft. Well, we've built in specifically in the law to let you know that this does not change existing Georgia law on self-defense. We have another series of code sections that govern our conduct, that let you know when can you use deadly force to protect yourself, to protect your house, to stop somebody else from being hurt. And there's a series of code sections that cover that. And if you'll look, starting at lines 96, going down through 100, that lays out these circumstances. Number one, we still have the right to self-defense. You may use reasonable force, including deadly force, to protect yourself or others in your presence that are under attack. If you are being threatened with deadly force, you may respond in kind. And nothing here changes the stand your ground law, where you do not have to retreat. You can stand your ground, and if somebody is using deadly force or threatening seriously bodily harm against you, you may still defend yourself just like we've always been able to do in the state of Georgia. In addition, you can also use force, including deadly force, to defend your residence, defense of your habitation. Some people refer to this as the castle doctrine. If you're at home and somebody comes breaking in your house at the middle of the night and you're in reasonable fear for your personal safety, or that a forcible felony is being committed against you or your family there in your household, you can use force that can cause serious bodily injury or even death to defend your home. So nothing in this law, by taking away citizens' arrest rights, prevents your right to defend yourself and others and your home. And finally, you can also use deadly force to prevent the commission of a forcible felony. So if you're in the bank and the robber comes in with their guns drawn, threatening people in the bank, you can detain that person and you can pull a gun on them if need be to stop them. Say, stop right there, drop your gun, or I'm going to use force to stop you from committing this forcible felony. If you see the little old lady trying to cross the street and somebody comes to knock her down and steal her purse, that's a forcible felony. You can stop that person from doing it. We're allowing people to use the same legal principles and statutes that we've had in place for decades, if not longer, to defend yourself, others from physical confrontation, your habitation, and also to stop the commission of a forcible felony that you're observing. Finally, there's a statute that allows you, we call it justification. Any other conduct that, when analyzed under all reasonable analysis, was justified under the circumstances, you're still allowed to do. And some of this will require court interpretation. Seeing somebody walking through your neighborhood, though, that you suspect might have stolen property from somebody else would not justify you to use deadly force. This stops that type of behavior. I can answer any questions you have, but because you can come up with just really dozens of potential scenarios. But if you just get it in your head, you can still defend yourself and others from physical attacks. You can still defend your home from invasion, from any attempt to commit a forcible felony there, or to, that puts you in apprehension for your safety. To stop a forcible, violent crime against somebody else, you can still interfere with that. Other crimes that you see, you can't use deadly force to stop somebody if you think they might have stolen the TV from somebody's house down the street. Because sometimes this leads to consequences that aren't intended. When citizens try to play police officer, not being trained and not having the full picture, then that's where we come up with these problems. So it attempts to stop that. There's one final provision on the final couple of pages, page 6 and 7, that deals back to the shoplifting circumstances. And what it does is protect the owner of the retail establishment or the food service establishment that we've given the ability to detain people that they think are stealing from them. It gives them immunity from a civil lawsuit if they reasonably believed that the individual was committing a crime and stealing their property or their services. They can detain them. They still can't keep them for long. They have to either release them or get law enforcement there within a reasonable amount of time. So long as they had grounds to believe the person was stealing from them and that they didn't keep them too long or went ahead directly and called law enforcement, then they're immune from being sued for a false imprisonment or false arrest case. And that, Mr. President, I think is the explanation that folks are looking for here to know exactly what all this hullabaloo has been about the elimination of citizens arrest. I'm happy to take any questions if folks have them. If not, I urge you to adopt this law. Let's get with the times. Let's try to prevent citizens from taking the law into their own hands other than the limited circumstances that I've set forth.
You have no questions.
Thank you, Mr. President. I yield the well.
Chair recognizes the senator from the 37th to speak to his amendment.
Thank you, Mr. President, members of the Senate. Let me start by saying that I believe that Senate Bill 479 is a very well-reasoned bill. It covers what it should cover almost entirely, and I say almost. I think it lays out when a person can detain another individual on their property that's taking property that belongs to the business owner. He's covered, the senator from the 46th has covered a person's personal rights on their own property and in their own home. There's one omission I think that needs to be added to this bill. If you'll look at line 72 under the definitions of owner, the current bill says the owner means any person on his or her agent or employee who owns or operates a retail establishment or a food service establishment. Has a period right there. My amendment would seek to remove that period and continue on and say, or any business owning personal property located on their own property or on the property of others on which they are conducting their business activities. I don't think the right of defending your own personal property should only be limited to those who have retail establishments or food service establishments. There are many other businesses, some that have very expensive personal property that's owned in the business that are subject to theft. And I think all of these business owners need equal protection under the law. If it goes on down on line 85, it adds a new criteria there under line 7 in the amendment. It adds another definition of an owner and their options. An owner of any business entity operating on their own property or on the property of others on which they're doing business who have reasonable grounds to believe that the individual sought to be detained has committed or attempted to commit theft by taking, as set forth in Code Section 16-8-2, or theft of services as set forth in Code Section 16-8-5. This merely extends the right to preserve your own property by detaining those who would unlawfully and illegally be taking the property from a business, either on their own property or property on which they are conducting their business activities. Mr. President, if there's no questions, I'll yield the well.
Chair recognizes the senator from the 47th with a question.
Thank you, Mr. President. Would the senator yield?
Yes, sir.
You know, when we talk about businesses, I live on a farm. I don't know if you're going to call it a business or just a way to lose money, but I'm pretty good at both. Said one of the situations I think about in this legislation, and it may go back to the bill sponsor, said the senator from the 46. But for me, I have some elderly neighbors. We share a mailbox location together right at the end of their driveway. When I look at somebody come speeding out of their driveway in their vehicle with maybe a gun safe in the back or some loot that they have obviously stolen, said come speeding out the driveway, the way I understand this bill and my simple understanding of the law is I would not be at liberty to stop that individual and question them or hold them up in any way unless I had a business. And you know, the interpretation of what a business is, I'd like for you to expound on that if you can.
Well, clearly a business entity is a business entity that is carrying on trade with the public or government or whatever. But you know, I think the distinction in this is in this bill you have a right to detain someone that's taking the property that belongs to a business or the business for which you work. Personally, if you have a farm, I would think that your farm equipment is protected under this as well, but I'm not sure that you have, you clearly do not have a right to detain someone taking property from your neighbor. You have a right, as Senator from the 46 said, you have a right to come to the aid of that person if their safety and health is in danger. But I don't think you have a right to detain someone coming off of another person's property. I think that's the distinction that this law has. I think you would have the right to follow that vehicle that comes speeding off and also call law enforcement and give them the information either on tag numbers or whatever. But I don't think you specifically, this bill does not convey the right for you to intervene in the affairs of your neighbor unless it's your property or you're doing business on your neighbor's property. If it's your property, you have the right to do that.
Thank you.
You have no more questions.
I yield will.
Does any other senator wish to speak for or against the measure or the amendment? The chair sees none. All right, we'll take up the amendment. The question is on the adoption of amendment number 1 by the senator from the 37th. Is there objection to the adoption of the amendment? The chair hears none. There is objection. All those in favor of amendment number 1, vote yea. Opposed, nay. The secretary will unlock the machine. Have all senators voted? Have all senators voted? One more? Okay. Is the hallway clear? Mr. Secretary, will you please close the machine? On the adoption of amendment number 1, the yeas are 33, the nays are 19, and the amendment is adopted. All right, now we'll take up the measure. Is there objection or agreeing to the report of the committee which is favorable to the passage of the bill? The chair hears none. The report of the committee is agreed to. Is there objection to the main question being ordered? The chair hears none. The main question is ordered. Questions on the adoption of the bill as amended? All those in favor vote yea. Opposed, nay. The Secretary will unlock the machine. Have all senators voted? Have all senators voted? Mr. Secretary, please close the machine. On the passage of the bill, the yeas are 52, the nays are 1. This bill, having received the requisite constitutional majority, is therefore passed as amended. Chair recognizes the senator from the 14th for a motion.
No, it's not 320. It's 43. Thank you, Mr. President. I request unanimous consent to remove House Bill 43 from the table.
Mr. Secretary, please read the caption.
House Bill 43 by Representatives Cantrell of the 22nd and others. A bill to be entitled an act to amend Code Section 40-2-26 of the OCGA relating to form and contents of application for registration heavy vehicle tax and satisfactory proof of insurance so as to require motor vehicle registration application forms to include optional information regarding certain conditions which may interfere with a registrant's ability to communicate and for other purposes. The Senate Committee on Public Safety recommends that this bill do pass by substitute. Respectfully submitted, Senator Albers of the 56th Chairman. The Senate Committee on Public Safety offers the following substitute to House Bill 43, a bill to be entitled an act to amend Code Section 40-2-26 of the OCGA relating to form and contents of application for registration, heavy vehicle tax, and satisfactory proof of insurance, and for other purposes. This completes the order, Mr. President.
Senator from the 14th has asked for unanimous consent for House Bill 43 to be taken off the table. Is there objection? The chair hears none, and it is taken off the table. The chair recognizes the senator from the 14th to present the measure.
Thank you, Mr. President. This is just a common sense bill, and what it does is it allows an applicant for a license plate to indicate on the application whether or not there's a physical, mental, or neurological condition that in some way impedes the applicant's ability to communicate with an officer. With that, Mr. President, I ask you yield well and ask favorable consideration.
Senator has yielded the well. Does any other senator wish to speak for or against House Bill 43? The chair sees none. The question is on the adoption of the committee substitute. Is there objection to adoption of the committee substitute? The chair hears none. The committee substitute is adopted. Is there objection to agreeing to the report of the committee which is favorable to the passage of the bill? The chair hears none. The report of the committee is agreed to. Is there objection to the main question being ordered? The chair hears none, and the main question is ordered. Questions on the passage of the bill by substitute. All those in favor vote yea. Opposed, nay. The Secretary will unlock the machine. Have all senators voted? Have all senators voted? Ms. Secretary, please close the machine. On the passage of the bill, the yeas are 49, the nays are 4. This bill, having received the requisite constitutional majority, is therefore passed by substitute. Chair recognizes the senator from the 18th for a motion.
Thank you, Mr. President. I ask for unanimous consent to remove HB 94 from the table.
Ms. Secretary, please read the caption.
House Bill 94 by Representatives Rich of the 97th and others. A bill to be entitled an act to amend Article 1 of Chapter 8 of Title 16 of the OCGA relating to theft so as to provide for the crime of theft by possession of stolen mail and for other purposes. The Senate Committee on Judiciary recommends that this bill do pass by substitute. Respectfully submitted, Senator Strickland of the 17th, Chairman. Senate Judiciary offers the following substitute to House Bill 94. A bill to be entitled an act to amend Article 1 of Chapter 8 of Title 16 of the OCGA relating to theft so as to provide for the crime of theft by possession of stolen mail, to provide for the crime of porch piracy, and for other purposes. This completes the order, Mr. President.
Senator from the 18th has asked for House Bill 94 to be taken off the table. Is there objection? Chair hears none, and it is taken off the table. The chair recognizes the senator from the 18th to present the measure.
Thank you, Mr. President. Good evening, colleagues, or I guess we're still in the afternoon, headed toward the evening. I bring to you House Bill 94, which addresses a rising problem that we've got with the way that we live and receive packages and mail and things that we buy. You've probably heard the term porch piracy, of folks that are involved in criminal activity, of going up on our porches and stealing our materials and stealing things that the mailman and that the UPS and the FedEx guy delivers. So what this bill does is addresses that issue, and it does it in two fashions. It sets out in line 11, it defines mail, and you'll see on line 16 the definition of possessing stolen mail. And in lines 21 through 24, it says that a person will be guilty of the crime of theft of possession of stolen mail if they possess 3 or more items from different mailboxes and possess a minimum of 10 separate pieces of stolen mail. You'll find in Section 2 the issue with regard to porch piracy, and that is the person would be guilty of a crime of porch piracy if they in fact have 3 or more envelopes, bags, or packages or related articles from someone's dwelling. Similarly, and one of the things that we did on the Senate side was we actually softened the bill. There were some concerns about making this a felony for the first time, but with the work of the committee, we actually modified it so that it is a felony. However, the trial judge, in his or her discretion, can make it a misdemeanor. So with that, Mr. President, I'm happy to answer any questions or yield the well.
You have no questions.
Thank you. I urge your consideration and vote for this bill. Thank you.
Any other senator wish to speak for or against House Bill 94? The chair sees none. The question is on the adoption of the committee substitute. Is there objection to adoption of the committee substitute? The chair hears none. The committee substitute is adopted. Is there objection to agreeing with the report of the committee which is favorable to the passage of the bill? The chair hears none. The report of the committee is agreed to. Is there objection to the main question being ordered? The chair hears none. The main question is ordered. Questions on the passage of the bill by substitute. All those in favor vote yea. Opposed nay. The secretary will unlock the machine. Have all senators voted? Mr. Secretary, please close the machine. On the passage of the bill, the yeas are 38, the nays are 14. This bill, having received the requisite constitutional majority, is therefore passed by substitute. Chair recognizes the senator from the 17th for a motion.
Mr. President, I move that House Bill 231 be taken off the table.
Ms. Secretary, can you please read the caption?
House Bill 231 by Representative Gaines of the 117th and others. A bill to be entitled an act to amend Article 7 of Chapter 5 of Title 16 and Article 1 of Chapter 13 of Title 19 of the OCGA relating to stalking and granting of relief by superior courts, respectively, so as to expand the applicability of protective orders involving victims of stalking and for other purposes. The Senate Committee on Judiciary recommends that this bill do pass by substitute. Respectfully submitted, Senator Strickland of the 17th, Chairman. Senate Judiciary offers the following substitute to House Bill 231. A bill to be entitled an act to amend Article 7 of Chapter 5 of Title 16 and Title 19 of the OCGA relating to stalking and domestic relations, respectively, so as to expand the applicability of protective orders involving victims of stalking and for other purposes. This completes the order, Mr. President.
Senator from the 17th has moved for House Bill 231 to be taken off the table. Is there objection? Chair hears none, and House Bill 231 is removed from the table. The chair recognizes the senator from the 17th to present the measure.
Thank you, Mr. President. Members of the Senate, I bring to you House Bill 231. House Bill 231 creates a new type of protective order, restraining order, to stop acts of violence a victim has experienced from someone they dated the past 6 months or are currently carrying the child of. Under current law, we have two different types of TPOs. This adds a third type. You have stalking TPOs, you have family violence TPOs, and now with this bill, you have dating violence TPOs. And it will cover a loophole that's not currently covered in the law, where you have somebody that's not married, they don't have any children yet, but you still have violence taking place in that relationship. Otherwise, we track the same language you have with the process, the other two types of TPOs under Georgia law with House Bill 231. Happy to answer any questions.
You have no questions.
I ask for a favorable consideration.
Does any of the senator wish to speak for or against House Bill 231? The chair sees none. Questions on the adoption of the committee substitute. Is there objection to adoption of the committee substitute? The chair hears none. Committee substitute is adopted. Is there objection to agreeing to the report of the committee which is favorable to the passage of the bill? Chair hears none. The report of the committee is agreed to. Is there objection to the main question being ordered? The chair hears none. The main question is ordered. Questions on the passage of the bill by substitute. All those in favor vote yea. Opposed nay. The secretary will unlock the machine. Have all senators voted? Mr. Secretary, please close the machine. On the passage of the bill, the yeas are 53, the nays are 0. This bill, having received the requisite constitutional majority, is therefore passed by substitute. Chair recognizes the senator from the 29th.
Mr. President, I respectfully ask that we remove House Bill 466 from the table.
Mr. Secretary, please read the caption.
House Bill 466 by Representatives Powell of the 32nd and others. A bill to be entitled an act to amend Chapter 5 of Title 40 and Chapter 13 of Title 43 of the OCGA relating to driver's licenses and driver training schools, respectively, so as to reduce the number of required hours in the intervention component of DUI, alcohol, or drug use risk reduction programs, and for other purposes. The Senate Committee on Public Safety recommends that this bill do pass by substitute. Respectfully submitted, Senator Albers of the 56th, Chairman. The Senate Public Safety Committee offers the following substitute to House Bill 466, a bill to be entitled an act to amend Chapter 5 of Title 40 and Chapter 13 of Title 43 of the OCGA relating to driver's licenses and driver training schools, respectively, so as to provide for driver education training courses, to provide for requirements for the issuance of Class C and Class D driver's licenses, and for other purposes. This completes the order, Mr. President.
Senator from the 29th has asked for House Bill 466 to be taken from the table. Is there objection? The chair hears none, and House Bill 466 is removed from the table. Chair recognizes the senator from the 29th to present the measure.
Thank you, Mr. President. Colleagues, House Bill 466 primarily increases the requirements for individuals here in Georgia that teach driver's training classes, especially those in-person driving training instructors. It also allows a military service member 17 years of age or older who has not held a Class D driver's license for at least 12 months, which is currently the requirement, to be eligible for a Class C license if such member provides proof of military enlistment and meets all other qualifications for a Class C license. And it establishes the parameters for licensing of some of the special license instructor courses for those conducting driver schools in different locations. And finally, it establishes where if an individual who currently owns a driver school and chooses to purchase additional locations or sells their school and moves to another part of the state to open up a school, that the time that they had and the certifications that they held while operating their previous school will count toward qualifications with DDS. It's a excellent piece of legislation and will sure to make our roads safer here in Georgia. And Mr. President, I will yield the well if there are no questions.
You have no questions.
Thank you, sir.
Any other senator wish to speak for or against House Bill 466? The chair sees none. The question is on the adoption of the committee substitute. Is there objection to adoption of the committee substitute? Chair hears none, and the committee substitute is adopted. Is there objection to agreeing to the report of the committee which is favorable to the passage of the bill? Chair hears none. The report of the committee is agreed to. Is there objection to the main question being ordered? Chair hears none, and the main question is ordered. Questions on the passage of the bill by substitute. All those in favor vote yea. Opposed, nay. The Secretary will unlock the machine. Have all senators voted? Mr. Secretary, please close the machine. On the passage of the bill, the yeas are 53, the nays are 0. This bill, having received the requisite constitutional majority, is therefore passed by substitute. Chair recognizes the senator from the 37th.
Mr. President, I would respectfully request the House Bill 449 be raised from the table.
Please read the captions, Mr. Secretary.
House Bill 449 by Representative Smith of the 133rd and others. A bill to be entitled an act to amend Chapter 9 of Title 25 of the OCGA relating to blasting or excavating near utility facilities so as to revise the Georgia Utility Facility Protection Act to enhance the processes for locate requests and to require that 911 be contacted if an excavator damages has a hazardous liquid pipeline and for other purposes. The Senate Committee on Regulated Industries and Utilities recommends that this bill do pass by committee substitute. Respectfully submitted, Senator Cowser of the 46th, Chairman. Regulated Industries and Utilities offers the following substitute to House Bill 449. A bill to be entitled an act to amend Chapter 9 of Title 25 of the OCGA relating to blasting or excavating near utility facilities so as to revise the Georgia Utility Facility Protection Act to enhance the processes for locate requests and to require that 911 be contacted if an excavator damages a gas or hazardous liquid pipeline and for other purposes. This completes the order, Mr. President.
The senator from the 37th has asked for unanimous consent to raise off the table House Bill 449. Is there objection? The chair hears none, and House Bill 449 is raised off the table. Chair recognizes the senator from the 37th. For what purpose does the senator from the 37th rise?
Mr. President, I don't have a copy of the substitute.
Secretary can get that for you on the way up here. Chair recognizes the senator from the 37th to speak to the measure.
Mr. President, members of the Senate, I bring you a utility locate bill today. The bill came to us from the House, had 4 specific areas that it dealt with. Aside from revising definitions, it dealt with blasting or excavation near utility facilities. It extended the notification time for that. It enhanced the processes for locate request and to require that 911 has to be contacted if an excavator damages a gas or hazardous liquid pipeline, to change and provide for certain definitions, to provide for certain procedures in extraordinary circumstances. And that means that if you're in a time when you have like a disaster such as a hurricane, a tornado, whatever, the time requested for locates would be suspended. It also provides for certain limitations on the recovery of costs and damages for utilities that are not located. When the bill came to committee, we took up some issues that should have been dealt with 25 years ago when the utility locate provisions were first put into place. Every buried utility in a public right-of-way is mandated for it to be located, with the exception of traffic control facilities and devices. Now, what does that mean? That means that when you're digging in the shoulder of the road, what we have that's supposed to be a one-call number that you call, it's not a one-call number. It's in fact, you're digging at your own jeopardy, because if you don't know the number to call on the DOT for the location for the traffic control facilities, you're out of luck. And if you happen to call the wrong facility, and some signals are located by counties, if you know the number to call and if you can get through to them, and there's no consistency on the answering and responding to these cases. The proposal, the change to the House bill, it leaves intact everything that the House does in their bill. But I would direct your attention to line 197. It adds a provision that an underground utility or facility includes an underground electronic traffic control device or an underground electronic traffic management system. That may not mean anything to you if you're not a ditch digger, a utility contractor. But these traffic control cables, I saw some over the weekend. They're putting in it on State Route 120 west of Marietta. Those cables are about 1.5 inches in diameter, and they're fiber optic. And any of you that have ever encountered that know that a fiber optic cable costs thousands of dollars to repair. It doesn't make sense that these facilities would not be covered under the Underground Protection Center. Why, after 25 years, is it not covered? Well, the reason it's not covered is because the people who are on the Georgia Utility Coordinating Council, and think about the definition of that name, Georgia Utilities Coordinating Council. So all is supposed to be coordinated, except the glaring omission of traffic control cables. And the reason it's omitted is because they couldn't come to an agreement that it ought to be located. Now, I can tell you, as a lifelong ditch digger, they need to be located, and it needs to be under the one call number. I don't know of any logical argument that you can make against bringing it under the protection. The one call system was set up for two reasons. It came about because there was a gas line that was jerked out of the side of a nursery, children's nursery, in Hapeville, Georgia. And it killed 8 people when that building blew up. And that was the genesis of the underground locate law. Since that time, it was expanded to telephone cables, cable TV, fiber cables of any type, water and sewer, all of the other utilities, with the exception of the buried services of traffic control devices and systems, because they could not agree that they needed to be located. We had very playful arguments made. Oh, the 16 people that sit on this board don't agree to it, and everybody has to agree. Well, let me tell you, I don't know why anybody would not agree that this needs to be located. And that's what this bill does. It also provided an exemption from this for the railroads. People say, well, why do you exempt the railroads? It's a very simple question. But it also has a very basic issue. It's private property. They own that property. The utilities that are on that property belong to the railroad unless they've given someone else license to be on it. And before you operate on a railroad right-of-way, you have to get a permit from them, and they approve your plans, and they show you what they have in place. The other exemption to this is by the request of the Georgia DOT. And they said because it's hard to keep updated on all the state roads in the state of Georgia, the DOT has a bank of that. And they said, we'll give you a one-call number to the state DOT. The DOT is just like the right-of-way. If you do work on their right-of-way, you've got to have a set of approved plans before you go to work, and you have to have a permit. And they have agreed that on these permits and on these plans, both the email address that you can notify them and request to locate, and the one-call number for the state DOT. Everybody that's in the ditch digging business knows when you're on a DOT right-of-way. I won't belabor the point, but the fact that people can't get together and agree that underground utilities need to be located is ludicrous. This is a common sense bill, and I ask you to vote for it in its entirety and reject the bill that leaves unmarked traffic signals okay in the state of Georgia. That's what this substitute does. Mr. President, if there's no questions, I'll yield the will.
Chair recognizes the senator from the 15th with a question.
Thank you, Mr. President. Senator Yield.
Yes, sir. Always.
Senator, isn't it true that the original bill selling point was that it had 16 organizations that had agreed to the bill as it was presented initially in the committee? Isn't that true?
That is correct.
And in addition to that, when you added your part to that to bring in the traffic signals, isn't it true that that was a component of that that said there would be a carrot, would be an incentive for them to go ahead and include the other and get that finished as well in the near future? A timeline.
Well, I don't know about a promised timeline. They've been talking about it for 25 years. They did say they'd get on it and look at it, but if they haven't been able to agree to do it in 25 years, Senator, I doubt they're going to do it in the next year.
When does your bill allow them to do it, Senator?
My bill allows them. This bill kicks into place on January 1 of 2022. So we're giving them 9 months to get the details worked out. And so we're giving them ample time, and we're delaying the implementation of it. Thank you, Senator. I appreciate it.
Chair recognizes the senator from the 53rd for a question.
Thank you, Mr. President. Senator Yield.
Yes, sir, always.
I am proud of this amendment that you have introduced. Isn't it true that your livelihood, you have laid pipe and dug in the dirt and done this exact work in the past?
For 51 years, we've gone in the hole every day.
Looky here. So in that 50 years, isn't it true that you've run across all this kind of other utilities and markers in the soil next to you or what marked properly, but because of the law and you trying to make sure the signals, isn't it a safety aspect if nothing else?
It's absolutely. This whole bill came about, number one, for public safety, and number two, to alleviate the inconvenience of the public. And how many of us have ever been at a crowded, busy intersection when the traffic lights went out and you had to sit there and trust somebody else's courtesy to go across one by one? It's time for this foolishness to stop. This bill needs to pass, and I would appreciate your passage of it.
Do you continue to yield?
Yes, sir.
Chair recognizes the senator from the 26th for a question. He waves. Chair recognizes the senator from the 33rd.
Thank you, Mr. President. Does Senator yield?
Absolutely.
Is it not true that you've dug deep enough over the years that you've run into the devil himself?
It's been enough years I couldn't quite hear you, Senator, but I'm sure what you say is probably true.
It was absolutely true. You have no more questions. Senator has yielded the well. Does any other senator wish to speak for or against House Bill 449? Chair sees none. The question is on the adoption of the committee substitute. Is there objection to adoption of the committee substitute? The chair hears none. The committee substitute is adopted. Is there objection to agreeing to the report of the committee, which is favorable to the passage of the bill? The chair hears none. The report of the committee is agreed to. Is there objection to the main question being ordered? The chair hears none. The main question is ordered. Questions on the passage of the bill by substitute. All those in favor vote yea. Opposed, nay. The secretary will unlock the machine. Have all senators voted? Have all senators voted? Mr. Secretary, please close the machine. On the passage of the bill, the yeas are 50, the nays are 3. This bill, having received the requisite constitutional majority, is therefore passed by substitute. Chair recognizes the senator from the 20th for a motion.
Mr. President, I ask for unanimous consent to remove House Bill 676 from the table.
Ms. Secretary, can you please read the caption?
House Bill 676 by Representative Houston of the 170th and others. A bill to be entitled an act to amend Title II of the OCGA relating to agriculture so as to create the Georgia Farmers Market and Produce Terminal Development Authority and for other purposes. The Senate Committee on Agriculture and Consumer Affairs recommends that this bill do pass by substitute. Respectfully submitted, Senator Walker of the 20th, Chairman. The Senate Committee on Agriculture and Consumer Affairs offers the following substitute to House Bill 676. A bill to be entitled an act to amend Article 2 of Chapter 10 of Title II of the OCGA relating to farmers markets so as to provide for oversight by a legislative advisory committee and for other purposes. This completes the order, Mr. President.
Senator from the 20th has asked for unanimous consent for House Bill 676 to be taken off the table. Is there objection? Chair hears none, and it is taken from the table. The chair recognizes the senator from the 20th to present the measure.
Thank you, Mr. President. Colleagues, I bring you a Senate Ag Committee substitute to House Bill 676 related to our state farmers markets. The Georgia Department of Agriculture operates 9 farmers markets around the state to promote the handling, packing, transporting, storage, distribution, inspection, and sale of agricultural products. The markets are located in Atlanta, Augusta, Cairo, Cordele, Macon, Moultrie, Savannah, Thomasville, and Valdosta. According to the Georgia Department of Agriculture in fiscal year 2019, the markets generated approximately $7 million in revenue from leases, rents, gate tickets, and truck scale fees, and expended approximately $3 million for a net profit of about $4 million. The Atlanta market, the largest and most comprehensive of the markets, is responsible for 84% of the total revenue and generates 61% of the total expenditures. We have agriculture, as you know, is so important to our state, and we want to have first-class farmers markets that are serving the farmers and consumers of Georgia and promoting Georgia-grown products. Some of our markets, a lot of them are very old, well, they're all very old. Some of them are now located in areas that are not really suitable anymore. We've talked about setting up an authority and other methods to try to address the long-range needs of these markets, and we came to the conclusion that we wanted to establish a legislative oversight committee to look at these and commission a study by an independent consulting firm to give us an outside look at the viability of the various locations, look at ways we can improve the operations, tell us what properties may need to be divested, what the highest and best use of those properties are, and come back and report to the committee, and then we can make recommendations to the Commissioner of Ag and to the legislature. So that's what this bill does, is it establishes a 10-member legislative oversight committee made up of 5 members of the Senate and 5 members of the House. And I'd be happy to answer any questions if there are any.
Chair recognizes the senator from the 34th with a question. Senator from the 34th have a question? It's a long day.
Very long, and it's getting about, well, anyway. Is it not true that the market you spoke about in Atlanta is actually located in Clayton County and Forest Parkway?
That's correct. Senator knows what she speaks.
Chair recognizes the senator from the 21st with a question.
Thank you, Mr. President. Senator Yield.
Yes, sir.
So these farmers markets, I think you said, generate $7 million in revenue?
Roughly, yes, sir.
Is there a dedicated person in the agriculture department that oversees these 9 locations throughout the state?
There is, yes, sir.
So is there really a need for this? If there's somebody dedicated to really overseeing and supervising all these markets, do we need to create another level of advisory board?
Well, it's an oversight. The legislature, I'll just be frank with you, we're not satisfied with the way they're being operated. And we think improvements need to be made and some hard decisions need to be made about some of the property being, that are losing money or getting very little traffic and are not serving their intended purpose. And we feel like we need to get an outside firm to really analyze that, get us the data. We've had a hard time getting the data that we need. I do have a sunset in the bill, so this will not go on forever. It'll sunset in 5 years.
Okay.
But
thank you, Senator.
yeah, thank you for the question.
You have no more questions.
All right, I'd ask for your favorable consideration. Thank you.
Any other senator wish to speak for or against House Bill 676? The chair sees none. The question is on the adoption of the committee substitute. Is there objection to adoption of the committee substitute? The chair hears none. The committee substitute is adopted. Is there objection to agreeing to the report of the committee, which is favorable to the passage of the bill? The chair hears none. The report of the committee is agreed to. Is there objection to the main question being ordered? Chair hears none. The main question is ordered. Questions on the passage of the bill by substitute. All those in favor vote yea. Opposed nay. Secretary will unlock the machine. Have all senators voted? Have all senators voted? Got a thumbs up? Mr. Secretary, please close the machine. On the passage of the bill, the yeas are 49, the nays are 3. This bill, having received the requisite constitutional majority, is therefore passed by substitute. All right, quick update on our posture. We're going to take a dinner break here. And in the interim, the rules chairman do you know it yet that you're going to have a rules? Chair recognizes the rules chairman to make a quick announcement.
Mr. President, just want to wake you up. We have a rules meeting after you get your dinner, so please make yourself at home and get fed, and then let's meet about 6:30 in room 450, rules members. Thank you, Mr. President.
Breaking for dinner now. Rules meeting at 6:30. We'll come back to order at 7 o'clock. We'll stand at ease until 7 o'clock.